Welcome to BC Foster Basics. I'm Shamshara Pannon, a foster parent in the Lower Mainland of BC with 29 years of experience. BC's Child, Family and Community Service Act, commonly called the CFCSA, Section 54.1 and 54.01, discuss two different types of permanent transfer of custody for children who are and are not in continuing custody of the director. Let's discuss a few things about the benefits of transfer of custody for both caregivers and children. Benefits of transfer of custody. People choose to become guardians for numerous reasons. Parenting children and youth that you have a strong attachment to is the key reason, but there are additional reasons and benefits as well. Guardianship affirms a long-term commitment that provides a child with stability and security. Providing permanency to a child is invaluable for a sense of belonging, which is key to identity development. Belonging and having stable, healthy, and lasting relationships greatly improves social, emotional, and physical outcomes in the future. It's also a supportive way to ensure a child's cultural connections and practices are upheld. Guardians can support the child's ongoing relationship with parents and other family members, while ensuring consistency, safety, and security. Children's names are not changed with the transfer of a guardianship. They maintain any pre-existing inheritance rights or succession to property rights, and Indigenous children's rights are not affected. BC's permanent transfer of custody options through the CFCSA provide some financial assistance for guardians who may otherwise not be able to commit to raising a child. CFCSA sections 54.01 and 54.1. Let's go over what the CFCSA's permanent transfer of custody sections have in common and what sets them apart. Both Section 54.01 and Section 54.1 address the permanent transfer of custody of a child or youth. Custody and guardianship determines who has the authority to make decisions and to provide consent on behalf of the child or youth. In both types of transfer of custody, permanent custody of children and youth is transferred to family members or other caring individuals. In both types of transfer of custody, once the transfer has taken place, any future legal matters related to guardianship will fall under the Family Law Act. The difference between them is that a Section 54.01 addresses the transfer of custody of children and youth who are not currently in care under a continuing care order or a CCO. And Section 54.1 addresses children and youth who are in care under a CCO. Children in care through a CCO are officially in custody of the Ministry of Children and Family Development. Section 54.01 and transfer of custody for children prior to a continuing custody order. Section 54.01 addresses transfers of custody which happen before a CCO is in place. But what does that mean? Simply put, it means that the section of legislation allows the ministry to find a permanent caregiver for children or youth before moving into further legal processes. Typically, this caregiver will be a member of the child or youth's family or extended family who has already been looking after the child for at least 6 consecutive months through an extended family program agreement or a temporary custody to other agreement. These types of agreements are done under the ministry's out-of-care policies. The intention of out-of-care policies is to keep children or youth who cannot live safely with their own birth families out of ministry care when there are family members who are available to provide temporary or permanent care for them instead. If not family or extended family, eligible guardians will either be those with an established relationship with the child or those who have a traditional or cultural responsibility for their care. Following a transfer of custody under Section 54.01, pre-existing access orders automatically become an agreement solely between the new guardian and the person granted access under the order. The order can no longer be confirmed, modified, or canceled under the CFCSA. Legal matters such as these then fall under the Family Law Act. A person who receives custody under the section is eligible to receive financial support, usually matching the foster care maintenance for the child's age group. However, they will assume all other expenses, including medical and dental costs. Section 54.1, Transfer of Custody for Children who are in care. Section 54.1 of the CFCSA addresses a transfer of custody for children and youth who are in the care of ministry through a continuing custody order. The ministry, as the guardian of the child, can provide the necessary consents to transfer guardianship. In this case, the ministry may transfer guardianship to an individual inside or outside of the child or youth's family or extended family. 54.1 transfers of custody require that the child has been in the care of the proposed guardian for a minimum of 6 consecutive months. This could be through a restricted foster placement. Similarly to Section 54.01, once a custody transfer has been completed under Section 54.1, any existing access orders can no longer be confirmed, modified, or cancelled under the CFCSA itself. Pre-existing access orders become a matter between the guardian and the person who is granted access. Transfers of guardianship under Section 54.1 also receive some funding in the form of standard foster care rates, excluding coverage for medical and dental expenses. Guardians with custody through Section 54.1 are not eligible for the child tax benefit. However, if a child or youth is eligible for the child disability benefit, this additional monthly amount will be added on to the new guardian's monthly financial support. This is the same for 54.01, transfer of custody. Differences from adoption. Lastly, the details which make Section 54 transfers different from a standard adoption are: the child retains their surname and the birth parent remains listed on the birth certificate. The guardian does not acquire any rights to the child's estate or inheritance, and nor does the child acquire any rights to the guardians unless added to the guardian's will. Legal obligations between the youth and the guardian end on the youth's 19th birthday. For more information about permanent transfer of custody of a child, please contact your social worker or the Ministry of Children and Family and Development. Thank you for watching BC Foster Parent Association's BC Foster Basics series. You can reach us at 1-800-663-9999.